Okay, well, we're going to do this second part of the sentencing section for corrections. And we took a break here because this part is different than the rest. And that is where we talk about civil commitment of sexual predators. The thing about it is that people at every level have this stated belief that sex offenders, this is primarily child molesters, cannot be cured once they get started. There's no stopping them. That is true for a small percentage of people involved in this, but there are different kinds of cases. We just say somebody is a sexual predator or a child molester or whatever. We have to be very careful because we have these cases called Romeo and Juliet cases. Some states have adopted this new statute called Romeo and Juliet, and basically what that is if there's 4 years or less between an adult and a teenager, then they can use this defense as a complete defense to child molesting or statutory rape. And basically the way it goes is that it comes out of the Shakespeare novel Romeo and Juliet, but it basically talks about sex between younger people. And so in a lot of cases, and I've seen them, 19-year-old boy, sex with a 15-year-old girl, he goes to prison for 7 years. It's really unfair, it's really not just, but it's just the way the law used to be. Well, now today, they have new statutes called this Romeo and Juliet statute. So the court has to be very careful when we get into this because they're a far extreme of child molesting and sexual predators from people who are just teenagers. They fall in love, they have sex, the girl might even have a baby, and in the old days the guy just got sent to prison. Well, now today with this Romeo and Juliet defense, it's a complete defense, which means if he's 19 and she's 15, there's only 4 years apart there, then they are allowed to make a consensual sexual agreement, even though statutory rape says that she cannot. And so that is an exception. When we talk about child molesters, there's a lot of people out there who are younger individuals that get involved with sex with other younger individuals, and that does not mean that that it should be illegal. I like to tell the story about my neighbor when I was a little kid. She got married when she was 15 in Kentucky. She moved up to Indiana, and by the time she was 19, she had like 4 kids. You know, by the time she's 20, she had 5. And so she was the sweetest, kindest lady, though. She was like a second mother to me. She took good care of me my whole life. She actually invited us to her church, and we ended up going to her church, and that's been our family church for all these years since. So she's been a really sweet person in my life. But here in those times, you know, it was not uncommon for young women to get married at an early age. If you look back in time, even in the pioneer days and stuff, many cases where people were very young and fell in love and got married and then struck out to make their fortune in the West. So this has happened. Now today we've somehow adopted this Victorian idea that people need to be 18 before they should engage in sex. Some states it's 16. But there are exceptions to that, and that's what I wanted to bring out. But on the far end of the other end of the scale, you have child molesters who do engage in child molesting on repetitive times where it's like a 40-year-old man and an 8-year-old child. That is totally out of bounds and completely wrong, and something needs to be done. And some of these guys, the downside of it is that they engage with the child in sex, and then after they've been caught a time or two, they start killing the children. They graduate to become serial killers. So it's a very dangerous problem. It's a big issue. So when we're talking about a true sexual predator, that's a person with repeated offenses, and there is a keynote case which I have on the board. It's this Hendricks versus Kansas. I think in this appeals level it was actually Kansas versus Hendricks. I'm going to put up the case number for this. And this is a multiple offense child molester in the state of Kansas. Had served his long sentence, but had a history of child molesting on his record. And basically, he was diagnosed as a pedophile, and he agreed under oath that he was a pedophile, as a matter of fact. So they had this new law they passed called the Sexually Violent Predator Act, and as a result of that Sexually Violent Predator Act, their theory was that, based upon the information that they have, that they will commit, after the guy serves, let's say, 20 years, then they find him to be mentally ill, but guilty but mentally ill, and they put him in a mental hospital. So he comes right out of prison after many years in prison, goes right into a mental hospital. Well, that went up to the U.S. Supreme Court on appeal in this case, 521 U.S. 346, and this is a 1997 case. And it was a hue and cry. There were a lot of people, experts in the field, that said, well, this seems like double jeopardy to me. And so there was a big argument about that and discussion. And so in the case of Kansas versus Hendricks, which is the final appeal, the U.S. Supreme Court decided that it was not double jeopardy. It was basically allowable under the circumstances, because in this guy's case, he had even agreed that he was a sexual predator. He agreed that he had a problem with pedophilia. And so as a result, they said that it was proper, that he had had his due process, that it's a separate civil proceeding, and it was not a criminal proceeding, and it dealt more with his mental illness and not with any kind of criminal conduct that he was engaged in. So they said as a repeated engagement in sexual crimes with children or child molesting is evidence that a person has an inclination to repeat such offenses, and until he can be treated, he has to be kept away from society in a mental hospital. And so as a result, in Kansas versus Hendricks, there was a determination that there was no violation of double jeopardy, and it was a civil commitment rather than a criminal commitment. So that's very important, I think, and it's kind of tells us that there is an avenue to follow if, in fact, the person has a continuing pattern of sex crimes. It's interesting because I went back and I looked again at the Minnesota sentencing guidelines that are also mentioned in your book, and they're on my list of things to look at. And this is what these grids look like in these sentencing guidelines. I don't know how well you can see it. We'll try to get it where it's not too big, where you can't really understand it, but this is what it looks like. So you notice that there's these grayed out areas, and so what it basically, this is the sex offender grid, and this is the list of sentencing of what's available to the judges. And then basically this is the standard guideline for other crimes like burglary and theft and things like that. So you might want to spend some time looking at those. They took effect in August of 2012. It's just one example. It's Minnesota. There's also federal guidelines that you can look at. But basically it's important that they have scoring as far as their criminal history. That plays a big part. Do they have a prior record? Also, do they have any kind of issues with violence, pornography, a number of different things, solicitation, and so basically you get down to a score of 6 or more, then you're basically in a position where you have to spend substantial time in prison. You can look at that yourself. Looks like 360 months. And then down at the bottom level, then it goes down to 36 months, which is basically 3 years. So Those are issues that you need to look at. Indecent exposure, for example, if you score like a 4, that's 39 months. The range is 34 to 46. 60 months for a multiple offender with higher scores. And so these are the kind of things that we need to look at. And this here again is an example. It demonstrates this concept that we've talked about of proportionality in sentencing. Proportionality in sentencing. I like to talk about sex offenses because I've had many students over the years say, well, my solution for child molesting is just take them out and shoot them. So basically you fondle a child, take them out and shoot them. You engage in oral sex with a child, take them out and shoot them. You have anal sex with a child, take them out and shoot them. I mean, so basically what you have is that there is a difference between indecent exposure, fondling, and some of these other things until you get into actual intercourse. And then another point is, what was the age of the child? The more tender the child is as far as younger years, that is usually considered a much more serious offense. So these are tough parts to talk about. A lot of people have a lot of emotion involved in this. I will say that I did represent child molesters over time, and it wasn't easy. It was very difficult. But I do believe that people have the right to be represented for every kind of offense. Timothy McVeigh kills all these children in Oklahoma City, for example. He was entitled to a defense under our Constitution, and he received one. And so that's basically the standard. There's a lot of people out there that if you're an attorney and you represent a child molester, you might as well be a child molester yourself. And I don't think that's true. I think that's very bad. And so it's something to really give consideration to. Tough to maintain objectivity when we're dealing with child molesting, but it is a compelling part of this course. So give it some consideration. I don't expect to change your mind if you believe that we should hang them all by the big oak tree, but there's other ways to do this, and I'm just trying to tell you what really happens in the real courts when they're engaged in sentencing. So hey, thanks for your attention today. Hope you got something out of this, and we'll be back with you again soon. Thank you.